The Senate, page 12. Senate Bill 924 is passed the House with amendments.
The senator from Hanover, Senator McDougal.
Mr. President, move that the House amendments be accepted, and speaking to those briefly.
Senator has the floor.
Mr. President, this is the bill that was passed by for the day yesterday. Just to briefly remind the members, the bill that we had added that required that nursing homes and hospitals put in policies for public safety, emergency disasters, and for infectious disease outbreaks. And then the House added some significant amendments relating to the formation of abortion clinic regulations by the Department of Health.
Thank you, Senator. The senator from Hampton, Senator Locke.
Mr. President, speaking against the amendments.
Senator has the floor.
Mr. President, these amendments are draconian and patriarchal at best, and they're a means to backdoor a method to erode the rights of women to a safe and legal abortion. Does Virginia really want to take the lead in such obstruction? The American College of Obstetrics and Gynecology Council, representing physicians from across the state, disapproves of these amendments. Physicians are saying that patient safety is a key issue for the American Council of Obstetrics and Gynecology. This bill being considered must be opposed because it adds regulatory activity to small outpatient clinics which perform procedures. They also add that allowing this bill to be passed opens the door to Big Brother to regulate all of doctors' and patients' practices. And further, this is a slippery slope and will result in rules and regulations that become ridiculous when applied to the wrong situation. Therefore, Mr. President, I think that these amendments are out of line with where we are with respect to the rights of women, and I would move that we reject the amendments.
Thank you, Senator. Senator from Roanoke City, Senator Edwards.
Mr. President, members of the Senate, I rise to speak in opposition to the House amendments. I spoke yesterday about this and noted that there's been no state that has adopted legislation of this nature, which would require first trimester abortions to be performed in a hospital. That would include, as I mentioned yesterday, even medical abortions, which are not procedural, as you know. Mr. President, there's a reason for this. The fact that no other state has adopted an anti-abortion legislation this sweeping and this broad. And the reason is very simple. It's unconstitutional. It's unconstitutional for a couple of different reasons. We know from Roe versus Wade, regardless of what you think about it, it's the law of the land, dealing with privacy rights, and Planned Parenthood versus Casey, that the state cannot impose an undue burden upon the privacy rights of a woman with regard to the decision of whether to have an abortion during their first trimester. We know these procedures are safe. You've heard from the doctor, the senator from Norfolk, with regard to that, and I suspect you might hear some more from him this morning. But the fact of the matter is, Mr. President, that the undue burden is due to the fact that the costs would go up by having all first trimester abortions occurring in hospitals. Significant costs, which, by the way, raises some serious financial concerns, I would think, with regard to hospitals, perhaps a financial concern with regard to the Commonwealth of Virginia, which raises a question, should this be referred to the Finance Committee? I'm not making that motion, but that's a serious concern. What about health care plans? What about the overall cost to a woman to have to go to have a first trimester abortion in a hospital? And then what about access? How many hospitals, the access factor deals with poor women who don't have the funds to go to a hospital for an abortion. The effect on poor people. It's not going to have any effect on wealthy people if they have to go to a hospital. But it's certainly going to have an impact on low-income women throughout the Commonwealth of Virginia. That's something that was never considered, apparently, when this was put in. So it's clearly unconstitutional under Roe versus Wade and under Planned Parenthood versus Casey because it imposes an undue burden on a woman to have a first trimester abortion, which is a very simple procedure. But this bill goes beyond that. It adds another serious constitutional issue, which I don't think has been raised before in any of these kinds of cases. And that is the fact that it violates the Equal Protection Clause of the 14th Amendment. This clause has to do with treating similar situations the same way. If indeed it is true, as the evidence shows, that a first trimester abortion is a simple procedure, a safe procedure, not unlike so many other procedures that are handled in a doctor's clinic or doctor's office, then it should be treated like all other procedures handled in a doctor's office that are safe and simple. And we've gone through a series of those, as the senator from Norfolk has mentioned yesterday. But the fact that this is being treated separately and more onerously than any other procedure in a doctor's clinic would suggest you either do one of two things. You treat all inpatient procedures in a doctor's clinic as ones that should be handled in a hospital. Now, we would never do that. Can you imagine the uproar if all procedures a physician today provides and performs in the doctor's office or the doctor's clinic, if every one of them had to be in a hospital? Can you imagine the cost to the Commonwealth of doing that? That would make it constitutional, though, if you did this. But we would never think of anything so unreasonable and totally so unnecessary as that. But the fact that you're taking this simple procedure that has been done for years in doctors' clinics, doctors' hospitals, and saying this has to be done in a hospital as opposed to a clinic setting, sets this procedure apart from and treats it differently than other similar procedures. Therefore, it violates the Equal Protection Clause. Mr. President, the only benefit I see of having this passed is to give the Attorney General's office some more work to do, to go to court yet again to defend an unconstitutional piece of legislation. The Attorney General may be happy to do that. He's suing the University of Virginia. He's suing against the health care law that was passed by Congress, and so forth and so on. And maybe he'll be happy to do that. I don't know. But it will certainly give him additional workload. That's the only benefit I see, is to give more work for the Attorney General's office to defend a law which no other state has adopted because it's unconstitutional. Mr. President, I would hope this body would see that this is unconstitutional and vote not to adopt the House amendments. Thank you, Mr. President.
Thank you, Senator from Fauquier. Senator Vogel.
Thank you, Mr. President. Speaking to the amendment,
Senator has the floor.
I listened to my colleagues' discussion and debate yesterday on this measure and have listened to it today. And I carried this piece of legislation 2 years in a row, and so I have learned something more about the issue than I perhaps ever anticipated. And I will say that I feel compelled, while I respect both the legal statements that have been made by the senator from Roanoke and also the statements by the physician from Norfolk, I think it's important to set the record straight on just one or two very, very critical issues. And the first thing is this notion that this is not the case in other states. It is in fact the case, and in 30 other states in this country, licensure exists for such clinics. Whether they describe it as an ambulatory surgical center or some other clinic, they are licensed and they are regulated. And also, speaking to the issue of this being blatantly unconstitutional, I think I need to correct that as well, because the Fourth Circuit Court of Appeals has said that this is absolutely constitutional. This is something that states have the ability to regulate. And I would also say, speaking to the important issue, and I genuinely appreciate this idea of access and an undue burden. And we speak about that, the undue burden placed on the clinics, and I understand that. And we speak to the issue of access for women. But I don't believe I can emphasize enough that were I in the position, or were there someone in my family, my daughter or my sister or anybody who was going to have any kind of surgical procedure, think about the effort that you undertake. And it's certainly been the case in my family. Should we consider going to Duke? Should we consider going to Hopkins? What's the best clinic to have this done? We are creating a situation where, just from the access perspective, we are creating an environment where young women who already are not in, I would argue, the best sort of place in their life right now, who are struggling with lots of other issues, making this decision, that they don't have the option to have access to what I would consider is a clinic or a clinical environment that has been regulated, has been evaluated. And I noticed somewhere, and it was in emails or somewhere else, where the Secretary Remley had spoken about this issue. And Dr. Karen Remley, who's at the Virginia Health Commission, Commissioner Remley, I apologize, who said that it has been many years since we have had these kinds of clinics evaluated, and so no one can say exactly what is going on there. So to speak to this issue of access is to say that we are denying women access to a clinic where they have a guarantee, at least some modicum of a guarantee, that their health is being considered and that the clinic is safe. And when we heard the senator from Norfolk speak about what he does in the clinical setting in his office, he was talking about doing a spinal or creating the analogy to a breast biopsy. And he spoke to that notion of what kinds of issues can arise in his office when he does the spinal. And he spoke about the risk of infection and all of the other risks. And I would argue that a physician of his caliber working in that clinical setting is in a clinical setting where I think all of us would feel very confident. I do not believe that that is the case with these clinics. And so you're talking about those same kinds of risks. And I would also argue that that kind of a procedure is much, much different than a breast biopsy. And I'm not sure how many people in here have had a breast biopsy, but I can tell you that that is very different than the kinds of things that would occur in the course of having an abortion. And I would also tell you, with this question of undue burden and access, I cannot tell you how important it is that women have that option. And if you consider that right now in Virginia Beach and in Fairfax, we have a physician who was banned from engaging in the practice of medicine in New Jersey. He is not a licensed physician in Virginia, and he is here offering these services in a clinical setting to young women. And I would argue that most of the young women who come there, who are in the process of engaging in the abortion procedure, are probably not aware of the risks that they are placing their own life in this gentleman's hands. And I think that as a legislature, we're called on to consider many, many important issues that affect the health and the welfare of the citizens of the Commonwealth of Virginia. And some of them are a very low threshold, and some of them are a very high threshold. And I understand that this has been cast in the context of we are denying women the access to abortion. And it was stated yesterday on the Senate floor that this would ban abortion in the first trimester. And that is simply not the case. What we would be doing is we would be allowing Virginia to regulate these clinics the same way we regulate ambulatory surgical centers. And to say that those regulations have prevented people access in Virginia to ambulatory surgical centers is absurd.
Mr. President.
And so I would argue,
For what purpose does the
Would
senator rise?
the senator from Fauquier yield for a question?
Will the senator yield for question?
I would be happy to yield for a question.
Senator yield. Senator from Roanoke City,
Is the
Senator Edwards.
senator aware of any state that requires first trimester abortions to be performed in a hospital? Not that they have to be licensed or that they're regulated. Ambulatory surgical centers are not hospitals. Has any state required a first trimester abortion to be performed in a hospital as this House amendment requires?
Senator from Fauquier, Senator Vogel.
Mr. President, I would like to clarify that it is not my understanding that this requires this procedure to be done in a hospital setting. I think that there are 5 levels, I understand, of treatment or clinical environments up to and including a hospital. I would also say that in response to his question, and I'll answer the question about other states in one moment, but that is to say this does not require someone to go to a hospital.
Mr.
these
President,
clinics can be
with-
licensed, but in just one, if I may, I believe it is the case, and I could be wrong about this, that South Carolina has a very similar provision to the provision that we would be about to pass.
Mr. President, would the
Senator from
senator
Roanoke
yield
City,
for a
Senator
question?
Edwards.
Would the senator yield for a question?
Will the senator yield for an additional question?
Of course, I yield.
Senator yield. Senator
Isn't
from
it,
Roanoke City, Senator
Mr.
Edwards.
President, isn't it a fact that this amendment simply says that facilities in which 5 or more first trimester abortions per month are performed shall be classified as a category of hospital? It's a hospital. Isn't that what the amendment says?
Senator from Fauquier, Senator Vogel.
Mr. President, I think in the context of the traditional hospital setting that we think of a hospital, I do not believe that, in fact, it is that kind of a hospital. It is, in fact, something more analogous to the surgical centers where you go, where you can have a number of procedures done. But at the end of the day, Mr. President, I think we are missing our underlying obligation here, where this is not about banning abortions in Virginia. I think that, you know, I have integrity. I stand before this body telling you what I genuinely believe to be the case about this piece of legislation, and that is it is not about banning abortions. It is simply asking, it is simply caring for women who are about to have an invasive surgical procedure and creating an environment for them where they have the opportunity to do that in a place that is safe, where it considers their health, and where we have the opportunity to consider what reporting requirements arise out of those situations, so that should it become obvious that we have a serious issue in such a clinic, we have a way to report that. We have that opportunity in every other clinical setting to report if someone dies, if there are complications. And in speaking, and I promise this will be my last comment, and then I will sit down, in responding to what the senator from Norfolk said yesterday with respect to the clinical environment, I forgot what my point was going to be. I apologize, Mr. President. I had one last point and I just lost it. Anyway, thank you, Mr. President.
Thank you, Senator. The senator from Western Fairfax, Senator Marsden. Senator has the floor.
Thank you, Mr. President. I see a rather unfortunate parallel here. In my lifetime and in the lifetime of many people in this room, there was a constitutional right to vote. But we put obstacles here in Virginia and all throughout the southern states to put an obstacle to people exercising that constitutional right to vote. Poll taxes, literacy tests. And of course the argument was, well, of course we don't want people voting on that which they don't understand. And today, the ironic thing is the hospitals are places where infections are rampant, and it's probably the most dangerous place that you can go to have a procedure. I think you need to be careful here how we vote on this and what we're identifying with. And it's a rather unfortunate part of our history, and I think that what we need to do is keep the law exactly the way it is. Thank you, Mr. President.
Thanks, Senator. Senator from Alexandria, Senator Tyser.
Mr. President and members of the Senate, I've listened to this argument and discussion very carefully because it seems to me I have listened to it in one form or another for 16 years, and then some. And one of the benefits of serving in public office in a local setting is that you get to meet and see the situations in which a lot of people who are not like you are. And I cannot tell you how many people will be shut off from access because of this amendment. And it is because of the lack of privacy. And the nurses at Alexandria Hospital used to tell me many moons ago how tragic the people who came to the hospital for treatment after they had had a bad abortion. They had used coat hangers. They had gone to back alley places because they were afraid. They don't have, in many cases, they do not have mothers and fathers who are responsible, who take care of them, and who love them no matter what. I have heard of people, of young women who have stepfathers and significant others in the household who have threatened to throw young girls down the steps if they ever embarrass them like this, because it would embarrass them, they say. We had in Alexandria one time, we had a session for many people who were interested in the subject. And there was a woman whose daughter had eventually died because of a bad abortion. And she had a marvelous relationship with her daughter. She thought that she was on absolute, total sync with her daughter. She was well off. Her daughter was in good schools and so forth. And her daughter was going to visit a cousin for the weekend one time. And she went to visit for the weekend, and instead of going to visit the cousin, she went to one of the back alley places because she was so embarrassed and sorry at what she had done to embarrass her mother, whom she loved dearly. Her daughter ultimately died, and this woman was going around the state trying to tell people of the consequences of what this difficult situation was for her daughter. She said she wanted to be told. She would have taken her somewhere safe. She wouldn't have objected. She would have talked through it with her daughter, but she didn't. Her daughter did not do that, and it was all because she was embarrassed. That's a lack of privacy. You have a total lack of privacy if you have to go to a hospital, which is generally public, and many people have difficulty going to the hospital if they have a serious disease because they don't want other people to know it. They don't want the word to get around. So I can't imagine what many young women feel when they would have to tell somebody who was unsympathetic, who might be caring for them, and they would be kicked out of their homes. So I would hope that we would not take away the right to privacy and the right for anyone to do for himself or herself what he or she thinks is the right thing if it's interfering in their private life. Thank you.
Thanks, Senator. Senator from Southern Fairfax, Senator Barker.
Mr. President, speaking to the amendments.
Senator has the floor.
Mr. President, I rise to speak in opposition to the amendments that are before us here in terms of the amendments offered by the House, and I do so for three reasons. The first is that when we talk about abortions, many of us think of abortions as surgical procedures. But what's specifically addressed in these amendments is first trimester abortions. Many first trimester abortions, particularly early first trimester abortions, are medical procedures involving no surgical procedure. What we are doing, if these amendments are adopted, is in effect classifying a medical office providing a medical procedure, no surgical procedure, as a hospital and requiring them to meet hospital standards. That seems to me to be highly inappropriate. Secondly, I would say that having a background in working in the healthcare field in Virginia for more than 30 years, I'm well aware of many of the standards that exist for hospitals in terms of their operation, their physical structure, the designs of operating rooms, those types of things. In essence, what we're proposing to do here is to impose upon medical offices that are providing first trimester abortions standards that are required for hospitals for legitimate reasons, but would have no bearing whatsoever upon the quality of care and the outcomes and the safety of patients given services within those facilities. Third, what those imposition of those regulations would be is that, in fact, many facilities that now provide first trimester abortion services, both medical, those providing medical procedures and those that may or may not do surgical procedures during the first trimester, is a standard that they cannot meet. And my understanding is that more than 80% of the facilities and operations providing first trimester abortions in Virginia do not meet hospital standards. If more than 80% of those providing abortion services, first trimester abortion services, were to close, we could have as few as 4 facilities in the entire Commonwealth of Virginia. This would, in fact, pose a significant concern and a problem as it relates to access to care. It doesn't eliminate the provision of abortion services. It doesn't mean that someone can't access an abortion service within Virginia. It just has the potential for resulting in effect patients having to travel in many instances hundreds of miles to receive those services if they should do so. Many, particularly many of those with very limited resources, will be among those who probably would not receive services. And in effect, we would be setting up a two-tier system for those who have resources and are able to access them, those who live near the few facilities that are available, and those who cannot obtain access to care. I think that disparity in access to care is something that would be highly inappropriate, and I hope that we would not concur with the House amendments.
Thanks, Senator. Senator from Loudoun County, Senator Herring.
Mr. President, would the senator from Hanover yield for a question?
Will the senator from Hanover yield for a question?
I yield.
Senator yields. Senator from Loudoun County, Senator Herring.
Mr. President, the senator from Roanoke and a number of other members have spoken about the constitutionality or unconstitutionality of a provision like the amendment, and I was wondering if my distinguished friend and colleague, the senator from Hanover, has gotten assurances from the Attorney General that this amendment would be constitutional.
Senator from Hanover County, Senator McDougal. Sorry.
Mr. President, I would advise the senator from Fairfax, I have not spoken to the Attorney General on this matter.
Senator from Loudoun County, Senator Herring.
Well, Mr. President, again, some serious issues have been raised about the constitutionality or unconstitutionality of this amendment. Ultimately, members will have to make up their own minds as to whether it's constitutional or not, but I think that's important information that the state's chief legal advisor ought to have for us, and I know that this is the last day for action on bills. We still have a pretty long calendar, and I would like to have the bill go by temporarily to give the senator from Hanover an opportunity to request that from the Attorney General.
Without objection. Senator from Harrisonburg, Senator Obenshain.
Mr. President, I'd ask if the gentleman from Loudoun would yield for a question.
Will the senator from Loudoun yield for a question?
Yes, Mr. President, I yield.
Senator yields. Senator from Harrisonburg, Senator Obenshain.
Mr. President, I would ask, although I clearly am not the Attorney General of Virginia, would it satisfy the gentleman's curiosity if I were to be able to address some of the constitutional questions that have been raised in order for us to get on with business and to actually finish this debate and talk about those serious questions and move forward to a vote?
Senator from Loudoun County, Senator Herring. You have a question.
I yield to the senior senator from Fairfax.
Senator from Fairfax, Senator Saslaw.
They almost said it, Mr. President. Let me assure the senator from Harrisonburg, this bill will be voted up or down before we leave here. Everything has to be in conference or voted up or down tonight. So it will be, you got my word, we are going to vote on this.
Mr. President.
Senator from Harrisonburg, Senator Obenshain.
I would ask the gentleman, I do understand that, and that was not my purpose in standing up. My purpose was simply to offer to address some of the constitutional questions that have been raised and to ask if that would satisfy the gentleman in order for us to address those, talk about them, and continue to move on. I don't think anybody is talking about bringing the Attorney General in here to deliver a personal legal opinion to us, so I would make that offer and request.
Thank you, Senator. The motion on the floor is that the bill go by temporarily. Without objection, the junior senator from Virginia Beach, Senator McWaters.
Mr. President, not being fully sure of all the rules, I would like to discuss the amendment if that's proper at this time.
Well, Senator, the motion on the floor is that the bill go by temporarily. The senator from James City County, Senator Norman.
Mr. President, before we pass it by temporarily, I'd like to ask a relevant question of the senator from Loudoun, as it relates to his inquiry.
Will the senator from Loudoun County yield for a question?
Mr. President, I will yield.
Senator yields. Senator from James City County, Senator Norman.
Thank you, Mr. President. I would say that Senate Bill 924 catches absolutely none of the 40 senators on this floor as surprised today, as it has been on the calendar for a number of days, and it has been the subject of enormous internal discussions. My question, Mr. President, would be to the senator from Loudoun, knowing that this is the final day on which bills must be voted on, and being fully aware of the passion surrounding this bill, and respecting the fact that you are an esteemed attorney, prior to this moment of standing up on the floor, did you contact the Attorney General's office to ask for an opinion or interpretation on the constitutionality of this bill?
Senator from Loudoun County, Senator Herring.
Mr. President, I would say to my friend and colleague, the senator from James City County, I did not request that. Yesterday was the first time that we had an opportunity to debate it. The bill did not go through any committee at all. So this is a very new amendment to the bill, and I would have and would like to have the benefit of that information.
Yes, sir. Senator from James City County, Senator Norman.
I thank the gentleman for his very kind responses, and that triggers in my fertile imagination another relevant question that I would like to ask the senator from Harrisonburg, if that would be appropriate, prior to determine whether we pass it by temporarily for the purported purposes that have been stated.
Will the senator from Harrisonburg yield for a question?
I yield.
Senator yields. Senator from James City County, Senator Norman.
Mr. President, my question for the senator from Harrisonburg, respecting that he is engaged in the practice of law and frequently comes across a number of thorny constitutional issues, if he has looked into the constitutionality of this provision.
Senator from Harrisonburg, Senator Obenshain.
Mr. President, I would respond to the gentleman by saying, yes, these issues are well developed in the jurisprudence of the Fourth Circuit and the United States Supreme Court. I am familiar with some of the principles relating to the constitutionality of this proposal, and I would point out to the gentleman that the Fourth Circuit has clearly held that Virginia, states can clearly regulate first trimester abortions. The United States Supreme Court in Harris versus McCrae has held that abortions are inherently different from other medical procedures, and that is why federal courts have repeatedly affirmed the ability of states to regulate the provision of abortion services, and have repeatedly held that there is a legitimate interest in regulating abortion clinics, even in the words of the United States Supreme Court, more stringently than other medical facilities. Moreover, in Planned Parenthood versus Casey, the United States Supreme Court expressly held that state regulations that serve a valid purpose, such as furthering health and safety, do not strike at the abortion right itself, and that they are valid and within the constitutional authority of states to act. Moreover, if you go back to the seminal decision on abortion rights, the Roe versus Wade decision back in 1973, the United States Supreme Court expressly held and recognized the legitimate state interest in seeing that abortions are provided under circumstances that maximize patient safety. The federal courts have spoken repeatedly and clearly on this issue. There is no constitutional question, and simply standing up and saying that there is, don't make it so. Moreover, Mr. President, I would point out that in Virginia, there are 5 different...
What purpose does the senator rise?
Would the gentleman from Harrisonburg yield for a question?
Will the senator from Harrisonburg yield for a question?
I'm finished.
We'll yield when he's finished.
What I would further say is that the context in which this is placed is the context in which we're talking about regulations that are imposed upon hospitals. Now, you know, I attribute to some of those who've raised these questions perhaps some confusion as opposed to any effort to misstate these issues. But in Virginia, there are many different categories of hospitals, and what this is not talking about is requiring inpatient hospital treatment. We are talking about, I mean, there are different categories of hospitals, including inpatient, psychiatric, rehabilitation, acute long care, and outpatient surgical. Outpatient surgical centers are hospitals. they are defined as hospitals. And likewise, the fact that we designate this as a hospital doesn't mean that it has to be subject to the regulations that would apply to an inpatient hospital facility. In fact, all that would happen would be that
the question dealt with the constitutionality.
And this is in the context of that, in as much as it defines the scope of this and places it within the framework that the Supreme Court of the United States has established, in as much as this would simply subject abortion clinics in Virginia to a different category of regulations that would be promulgated by the Department of Health. So, Mr. President, I would respond to the gentleman by saying that the jurisprudence is ample and clear, and that there is no real question as to the constitutionality of this provision.
Thanks, sir. Now, will the senator yield for question?
I will.
Senator yield. Senator from Northern Fairfax.
Thank you,
Senator
Mr.
Howe.
President. I would ask the gentleman from Harrisonburg if he's the Attorney General.
Senator from Harrisonburg, Senator Obenshain.
As I recall, I think I prefaced my comments with a disclaimer. However, as the gentleman from James City County pointed out, don't need to be the Attorney General in order to be able to read Supreme Court cases, and particularly when they are as clear and definitive as the Supreme Court and the United States Court of Appeals for the Fourth Circuit have been on this issue.
Senator from Northern Fairfax.
Further question, Mr. President?
Will the senator yield for an additional question?
Of course.
Senator yields. Senator from Northern Fairfax. Senator
Will
Howe.
the senator from Harrisonburg be the one representing the Commonwealth in federal court?
Senator from Harrisonburg, Senator Obenshain.
Mr. President, of course I will not. I would ask in response whether the gentlelady from Northern Fairfax will be the person suing the Commonwealth.
Mr.
Senator from Northern
President,
Fairfax, Senator Howe.
Mr. President, I believe that we are requesting an opinion, informal opinion at this time because of the short amount of time remaining as to what the Attorney General's opinion is as to the constitutionality of this amendment.
Thank you, sir. The senator from Chesterfield, Senator Martin.
Mr. President, would the senator from Loudoun resume the floor for a question?
Will the senator from Loudoun yield for a question? For what purpose does the senator rise?
To express to ask the chair a point of order.
The senator has the floor.
Is not the motion on the floor to pass by temporarily, is that not the custom and practice of the Senate to grant such a motion?
That is the motion on the floor, Senator. I think the senators are debating that motion.
Mr. President, parliamentary inquiry.
Senator has the floor.
If my recollection of the rules is frail, I apologize to the other 39 of you, but it is my recollection that this is a motion that is debatable and is not articulated in our rules as a non-debatable motion.
The senator is correct.
Is that not correct, sir?
It is a debatable motion. Yes, the senator is correct. Will the senator from Loudoun County yield for a question?
Yes, Mr. President, I yield.
Senator yields. Senator from Chesterfield, Senator Martin.
Mr. President, just a few moments ago, as part of your reason for in the answer to the senator from James City's question about whether or not you had inquired of the Attorney General, you said that this is something that has just been sprung on us and that it was not something that was considered by a committee. Were you aware of House Bill 1428 that reported from the House and was heard by Senate Education and Health on this exact subject?
Senator from Loudoun County, Senator Herring.
Mr. President, I would say to the senator from Chesterfield that I am aware that there was a bill that was defeated in committee, that the proposed amendment is somewhat different, although it covers something of the same topic. And I would defer to his memory as to what I said. I don't think I said that it was just sprung on us, but it is relatively new, and this amendment did not go through committee and was first debated on the floor yesterday.
Further question.
Senator from Chesterfield, Senator Martin. Will the senator yield for an additional question?
Yes, Mr. President, I yield.
Senator yields. Senator from Chesterfield, Senator Martin.
In light of that fact, then, and because you have requested the Attorney General's opinion, why, since this subject has been on the table, why have you not sought it to date? And regardless of what the answer is from the Attorney General, will it alter your consideration and your vote on this bill?
Senator from Loudoun County, Senator Herring.
Mr. President, again, as I explained previously to the senator from James City County, I didn't request an opinion because I first saw it in the calendar yesterday when it was debated. As to whether it will change the outcome of my vote, it may depend on what the opinion is. I don't know. I think it's information that, given the case authority cited by another lawyer, the senator from Roanoke, who has raised some constitutional concerns, that it's information that all members ought to have to help us decide in our own minds whether we think it's constitutional or not. And certainly, even if the opinion comes back that he thinks it's constitutional, it may or may not affect how I would vote on it.
Senator from James City County, Senator Norman.
Mr. President, speaking to the prevailing motion,
Senator has the floor.
I find it interesting that the basis of the motion is to request an opinion of the Attorney General. And for those members of the body that are not attorneys, a couple of points that I would share with you based on my experience as a practicing trial attorney. Opinions of the Attorney General of Virginia are just that. They are an expression of the opinion of that particular Attorney General on that particular day based on that specific fact pattern. And while the opinion of the Attorney General can carry some efficacy of law, it only does that in the absence of clearly articulated laws or judicial decisions that have been rendered. So if you have an articulable law or judicial decisions that have been rendered, that opinion from any Attorney General is modest at best. Secondly, I would say as we debate whether or not we ought to request the opinion of the Attorney General on an issue that is within the breast of the legislative body on the last day that we can vote on it, I take you back until 2007. And I take you back until 2007 to be mindful of the opinions of the Attorney General. There are some of us, including myself, that left pints of blood on this legislative floor over the debate and ultimate passage of House Bill 3202, which was the omnibus transportation package. And some of you still look askance at me over my involvement in that bill. But what I do remember yes, you. What I do remember very vividly is those of us engaged in the promotion and passage of that bill, I say to my friend, the senator from Loudoun, were very proactive. And we went to the then Attorney General's office and asked about the constitutionality of every provision of House Bill 3202 and got a confirmation it was constitutional. And do you know what? Our friends right across the street, they're right across 9th Street, disagreed with us and declared portions of 3202 unconstitutional in spite of the fact that we had an Attorney General's opinion to the contrary. So, Mr. President, I just ask us to reflect back on the impact of that Attorney General's opinion and how a court deemed it completely different in their decision.
Thanks, Senator. The senior senator from Fairfax, Senator Saslaw.
Beginning of the motion, I would just say that same scenario seems likely to be the same thing again.
Thanks, sir. The primary motion is that the Senate concur with the House amendments. There is a substitute motion that the bill go by temporarily. Senator from Hanover, Senator McDougal.
Mr. President, I have still not spoken to the Attorney General, but my esteemed seatmate from the gentleman from Franklin did pull up a newspaper article that I can answer the gentleman's question if he would like to withdraw his motion and proceed at this time.
I do not see him
If the
withdrawing
gentleman
his
would
motion.
yield for a question.
Will the senator from Loudoun yield for a question?
Mr. President, I yield.
Senator yields. Senator from Hanover, Senator McDougal.
Mr. President, I would ask the senator from Loudoun if I can respond to his question about the Attorney General's opinion and whether this is violative of the Constitution of the United States, if he would like to proceed with the debate and withdraw his motion.
The senator from Loudoun County, Senator Herring.
Mr. President, I would say that, first of all, two things. I wanted to correct something that I'd said earlier in response to a question about whether the opinion would change my vote on the matter. And I meant to say it may change my opinion of whether it's constitutional or not. It may change other persons' votes. As a matter of policy, this is not an amendment that I would support, whether the Attorney General comes back either way. But I think it's important information that all members should have before we vote on it. And I would say to the senator from Hanover, while I'm sure the reporters were accurate in stating it, I haven't seen the article, and this is a serious matter that I think deserves serious attention, and I would like to know, at least informally, from the Attorney General or someone from his office as to what the official position would be of the state's chief legal officer.
Mr. President, I would offer a substitute motion that we stand for a 10-minute recess so I can obtain the Attorney General's written opinion that was issued in August of 2010 to provide for the members of the body.
Senator, we already have a substitute motion, Senator. That is that the bill go by temporarily. The senator from James City County, Senator Norman.
Mr. President, speaking to the motion, please.
Senator has the floor.
From my very myopic perspective, there's been a reasonable discussion, at least up to this point, about the motion itself, and I would respectfully ask that we pass it by temporarily. It's not like we don't have other business to do, and I would suggest, Mr. President, that if in fact the senator from Loudoun or someone else would like to make an inquiry of the AG's office, that they could do that as we pass it by temporarily, if I can just overcome the majority leader for 1 second here.
Mr. President.
Thanks, sir. Senator from Harrisonburg, Senator Obenshain.
Mr. President, I would advise Mr. President and members of the body that I have in my hand copies of the opinion of the Attorney General issued on August 20th, 2010, relating to expressly this issue as to the ability of the Commonwealth to regulate clinics that provide first trimester abortion services. And I would ask a page to deliver this to the chair, to the desk, in order to be distributed to the body so that we can get on with voting on this clearly controversial but clearly constitutional issue.
Mr. President.
Without objection, Senate Bill 924 will go by temporarily. Turning to page 12 of the calendar, Senate Bill 924. Senator from Hanover, Senator McDougal.
Mr. President, having been previously explained, I move that the House amendments pass. And speaking to that briefly, Mr. President.
Senator has the floor.
Mr. President, I was asked by the Senator to Loudoun if I had conversed with the Attorney General. At that time, I had not. I was able to ascertain that he had written a legal opinion on the matter. I think that legal opinion has been distributed to the members for their review. In addition, I took the few minutes during the recess to call the Attorney General and ask him the Senator's specific question, and that is, in his legal opinion, did he think the statute as drafted by the House of Delegates would pass constitutional muster? And his answer to that was absolutely. Mr. President, I would indicate that based on that we should proceed forward with the vote on this legislation. Thank you.
Thank you, Senator. Senator from Harrisonburg, Senator Obenshain.
Mr. President.
Senator, before you speak, let me say, I cannot recall who has already spoken once on this subject. I think just about everybody. So we will just kind of start with a clean slate, if that's okay. Well, relatively speaking. Yep. Senior Senator from Fairfax, Senator Sassalaw.
everybody knows where I am on this issue, but we got a tight schedule, and I really would prefer that we don't start from scratch. Thanks.
Well, to remind the members, the rules of the Senate provide that no member shall speak more than twice on a subject. So I do not recall from the prior debate exactly who spoke and who didn't, but if the members will remain mindful of that, it will help us move along. Senator from Harrisonburg, Senator Obenshake.
Mr. President, speaking in support of the amendments, I would point out to the body that I have circulated the Attorney General's August 20th opinion, and I would remind the members that the constitutionality question is going to turn not on the action that we take here today, but on the reasonableness of the regulations that are ultimately adopted by the Board of Health. I would also point out that there is a letter that is literally on its way over here from the Attorney General, in which the Attorney General said in response to current inquiries about the constitutionality of Senate Bill 924 as amended, it is my view that this legislation is constitutional. A previous opinion from this office, which is enclosed, sets forth the parameters for state regulation of facilities providing for abortion services. The Attorney General in that previous opinion and in the letter dated today points out that the seminal case on this issue is a Fourth Circuit decision decided by the United States Court of Appeals in 2000. It's the case Greenville Women's Clinic versus Bryant, in which the Fourth Circuit Court of Appeals addressed this very issue. In South Carolina, law was adopted and regulations were adopted which imposed regulations on facilities providing first trimester abortions in an amount in the amount of 5 or more per, in which 5 or more first trimester abortions were performed. The regulations in that case are very similar to the regulations that are provided for under Virginia law under Title 32.1. In that case, regulations concerned staffing rules, specified drug, equipment, laboratory availability, detailed record keeping, reporting duties, maintenance, safety, emergency policies, so on and so forth. And the Fourth Circuit Court of Appeals said there's nothing about that that renders that legislation unconstitutional, and recognized that the state has valid interest from the outset of the pregnancy in protecting the health of the woman and the life of the fetus. And that's what this is about. This is about protecting women's health. It is about applying the same standards, and you can look at me like that if you want, but it's about applying the same standards to abortion clinics as is applied to other facilities. Hospitals are defined in 32.1-123, and they're defined broadly as facilities that provide for diagnosis, treatment of medical, nursing services, surgical or non-surgical, for 2 or more non-related individuals, 2 or more non-related individuals, including hospitals known by varying nomenclature designations such as, well, so on and so forth. Basically, it includes outpatient surgical procedures, and there are, as I mentioned previously, many different categories of hospitals to which this applies. This does not require women who are seeking abortion services to seek those services in an inpatient hospital facility, not by any stretch of the imagination. I know that it's late in the session, debate has been long, rhetoric has soared on issues such as this and others, but the issue is really very simple, and this bill is very simple. It's been debated for a long time, for many years, as a matter of fact, and I would respectfully submit there are 2 sides to this policy issue. But one of the issues, but we don't need to create issues out of thin air. There is no question as to the constitutionality of a provision of this nature. Accordingly, Mr. President, I would urge the body to vote yes.
Thank you, Senator. Let me, before we proceed, we do have a number of other speakers. I realize this is an emotional issue. I would just ask all of the members to remain mindful of the rules and decorum of the Senate on both sides throughout the debate. The Senator from Powhatan, Senator Watkins.
Thank you, Mr. President.
Ladies and gentlemen of the Senate, I rise to speak on this issue with some reluctance because I'm not typically one that gets up on issues such as this. But I would say to you that I felt compelled to speak at this time for one reason, and that reason is I have fortunately had the opportunity over the past 20 years to serve on a board for a very large hospital facility here in the Richmond metropolitan area. 2 emergency rooms and over 750 beds that are run by that hospital system. And I have watched the evolution of medical care and the attention to medical care in this community, and that's what a lot of it gets based on. You will hear the term community level of care or community expectations with regard to care. And I'd say to you, Mr. President, ladies and gentlemen of the Senate, that is what this is about. I have watched the regulatory structure change and many, many types of surgery, be it inpatient or outpatient surgery, they have become very cognizant of the concerns for the care of the patient before and after the surgery. We are talking about the instance here of surgical procedures. Any surgical procedure can be dangerous. Some less so than others, yes, but any surgical procedure has the potential to be life-threatening, and I think that's something that we all need to keep in mind. This legislation, these amendments, would provide for a mechanism for new regulations that would be specifically tailored to the facilities where these procedures are performed to ensure the safety of the individual patient, the individual woman receiving care. The new regulations would not impose any undue burden on the ability to obtain an abortion in Virginia. There are many different categories, and we have seen those categories expand over the years. And many of the medical systems actually have spread out to have surgical centers, and they come under very tight regulations and very tight administrative oversight with regard to how those procedures are done and what must be available to the physicians and the nurses and the personnel involved. So, Mr. President and ladies and gentlemen of the Senate, this is all about that quality of care issue. This is all about patient health and patient safety, and I do hope that you will agree with the amendments to Senate Bill 924. Thank you.
Thank you, Senator. The Senator from Northern Fairfax, Senator Howell.
Thank you, Mr. President. Speaking to the amendment.
Senator has the floor.
This is a sad, sad day for the women of Virginia and our families. We're about to be the only state in the union that will require all first trimester abortions to be done in hospitals, not just surgical abortions, but also medical abortions. What we are doing is taking Virginia, which has a well-deserved reputation of being a moderate state, and radicalizing it. We will be the outlier among all 50 states. We will be denying access to poor, disadvantaged, and rural women to safe and legal abortions. 17 of our 21 abortion clinics are likely to close. The cost is likely to go up. People will not have access. And to what purpose? To what purpose? There's no data showing that our current system doesn't work. In fact, the people pushing for this amendment are the very same people who don't want women to have any access to abortions. This is just one more way to take away our rights. Like the senator from Alexandria, I remember what it was like before women had access to safe and legal abortions. I remember a friend who committed suicide. I remember a friend who had a back alley abortion and did not come out of it well. She was never able to have children. These are real life things that can happen. We had made a lot of progress in Virginia in having quality health care available to the women, regardless of their economic status. Now we're just taking away that access. We're taking away from poor, disadvantaged, and rural Virginian women and their families one important way to determine the size of their family. It's a very, very sad day for Virginia. Thank you.
Thank you, Senator. The senator from southeastern Fairfax County, Senator Puller.
Thank you, Mr. President. I find this a very awkward subject to discuss in public. I'm a very private person about these types of issues. And I, myself, when I got married, was pregnant with my son, who is now, I'm embarrassed to tell you how old he is, but he's a great guy and good friend of Chap's. He knows him. But the subject of abortion is a very, very, very private subject. And women don't want to have abortions. They don't want to go anyplace. They don't want they don't want to share their things, their private thoughts with other people. And I understand that. I too remember when abortions were illegal, but I was not aware that they were illegal because I hadn't tried to get one. And I knew some friends in college who were pregnant, and I knew only from them that they were illegal. But anyway, I have a question about this amendment. How come if you only do 4 or more first trimester abortions, they're considered safe, and you can, I guess, go on and keep on doing 4 or fewer first trimester abortions in these clinics, but if you do 5, you have to do them in a hospital. Can you all tell me the difference between doing 3 or 4 a month and doing 5 or more a month? Why do they have to be done in a more special place where they are going to cost a lot more money? It doesn't make much sense to me, and if they're safe for 4 or 3 or 2 or 1 a month, they should certainly be safe for 5 or 6 or 7 a month. It makes no sense to me, and I personally am going to vote against this amendment. Thank you, Mr. President.
Thank you, Senator. The junior senator from Henrico, Senator McEachin.
Mr. President, would the senator from Hanover resume the floor for purposes of a question?
Will the senator from Hanover yield for a question?
Mr. President, I yield.
The senator yields. Junior senator from Henrico, Senator McEachin.
Mr. President, I would ask the senator if he has been provided with the copy of the August 20th, 2010 opinion from the Attorney General offered to us by the senator from Harrisonburg.
Senator from Hanover, Senator McDougal.
Mr. President, to answer the senator, that I did receive it a few minutes ago on my desk.
The junior senator from Henrico, Senator McEachin.
Mr. President, I wonder if I could ask the senator to turn to page 6 of that opinion and to review the last paragraph. And does it not say to him what it says to me, that the state already has the authority to regulate these types of facilities?
The senator from Hanover, Senator McDougal.
Mr. President, reading that last paragraph on page 6, it indicates to me that the Attorney General's opinion says that the Commonwealth does have the authority to regulate facilities, and the persons performing procedures in those facilities as long as the regulations adhere to the aforementioned constitutional considerations.
Junior Senator from Henrico, Senator McEachin.
Will the senator yield for another question?
Will the senator yield for an additional
I continue to
question?
yield.
Senator yield. Junior Senator from Henrico, Senator McEachin.
Mr. President, given that he and I agree that this opinion suggests that the Commonwealth already has the ability to regulate these facilities for first trimester abortions, I would ask the senator then, what is the purpose of this bill?
Senator from Hanover, Senator McDougal.
Mr. President, I would tell the senator the purpose of my bill was to deal with issues relating to infectious disease, environmental disasters, and security issues. The amendments that the gentleman speaks to about whether the need for them or not, as I read the Attorney General's opinion, it says that the Commonwealth has the authority to regulate it. It doesn't say that they are currently regulating them.
Junior Senator from Henrico, Senator McEachin.
Further question, Mr. President.
Senator has the floor.
Mr. President, I would ask the senator, I agree, first I would say to the senator, I agree that this opinion doesn't say that these facilities are being regulated at the moment. And I agree with the senator that it does say that we have the ability to regulate these facilities. My question, sir, is what do these amendments add to the current state of Virginia's ability to regulate these facilities?
Senator from Hanover, Senator McDougal.
Mr. President, I would advise the gentleman, this is not my area of the law that I'm most well versed on, but that being said, I did pull up the administrative code while we had our recess, and it looks like there is some ability to regulate outpatient abortion clinics and be deemed a category of outpatient hospitals. Is my reading of the amendment and my reading of the Attorney General's opinion, it appears what the definition is and what qualifies for outpatient abortion clinic is the question, and that is specified in the amendment. I'd also advise the gentleman, as he well knows, just because it says it in the AG's opinion does not mean that it can't be codified, and frequently we go through and do codified things even if they are the practice. So I do think that the amendment expands what could currently be done in Virginia, and it does codify it.
I thank the senator.
Thank you, Senator. The senator from Arlington, Senator Whipple.
Mr. President, first trimester abortions in Virginia are safe. There is absolutely no need for this amendment, and nobody should pretend to themselves that they are making abortions in Virginia safer than they are now. They have one of the best records of any medical procedure that is undertaken. They are done in facilities that are classified as doctors' offices. We've talked about this. Other facilities classified as doctors' offices are ones where many more invasive procedures are performed. Dental surgery, colonoscopies, and others are in this very same category of facility. Absolutely all that will be accomplished by this vote is to restrict access to a safe and legal procedure to poor women. This does nothing to end abortions. It is purely discriminatory. It makes me heartsick. And I hope that each of us will think in our own conscience about what we are doing today before this vote is cast. Thank you, Mr. President.
Thank you, Senator. Senator from Franklin County, Senator Stanley.
Mr. President, speaking to the amendment.
Senator has the floor.
Thank you, Mr. President. As I listen to this debate today, of course, it's an emotional issue for us all. And as a lawyer in practice, and I read the code a lot and certainly have done so during this term, I must say that we must always get back to exactly what this amendment does. When we look at the code that it seeks to amend, which is with regard to health and safety issues, adding this line to line 28 after facilities by basically defining a clinic that performs first trimester abortions 5 or more within a month as a hospital, relates it back to the standards of health, hygiene, sanitation, and safety established and recognized by medical and healthcare professionals. What this seems to me is that this is not restricting access. This is not limiting access. This does not fly in the face of Roe versus Wade. It merely makes a standard for us all to ensure the health and the safety of those persons who enter those clinics with the intent to have an abortion. In that regard, we must understand that this is not an expansion of some purpose, but a limitation in the sense that it merely ensures and allows the Commonwealth of Virginia to regulate those facilities to make sure that no complications occur. And I would speak in support of that because I believe that is our obligation for the health and the safety and the welfare of people who enter these clinics. And I thank you, Mr. President.
Thank you, Senator. The Senator from Roanoke City, Senator Edwards.
Mr. President, to follow up on prior discussion, I want to thank the senator from Harrisonburg for providing the Attorney General's opinion of August the 20th, 2010, to Delegate Robert Marshall regarding the question of whether the Commonwealth can regulate facilities in which first trimester abortion services are provided and medical personnel who perform first trimester abortions. I recall when it came out, I looked at it at the time, and I did not have it at the forefront of my brain this morning when the issue came up, so I appreciate him providing this opinion. Several things are interesting about this opinion. First, the Attorney General does opine that the Commonwealth, and I would reiterate what the senator from James City County pointed out, that the Attorney General is an attorney, one attorney. His opinion may be persuasive to some, but it's certainly not the law of the land. But the Attorney General's opinion says that the Commonwealth does have authority to promulgate regulations for facilities in which first trimester abortions are performed, as well as providers of first trimester abortions, so long as the regulations adhere to constitutional limitations. And that, of course, begs the question as whether or not this would be constitutional. I would point out the Attorney General goes forward to say that he believes the Board of Health already has the authority to do what this amendment would do, which I believe, as the senator from Enrico pointed out, if that's the case, why do we need the bill? Let's see what the Board of Health does. It has not chosen thus far to go this far. And if the Board of Health wants to do that, then I suppose it would be challenged in court. That also begs the question, is it constitutional? But the Attorney General pointedly notes that on page 2, after going through some analysis, that to date, unlike later abortions, that is later term abortions, first trimester abortions are not required to be performed in licensed hospitals. That's the status of the law of Virginia today. Unless the Board of Health promulgates regulations, that remains the law. And this bill this amendment would simply say that facilities in which 5 or more first trimester abortions per month are performed shall be classified as a category of hospital. It does say category of hospital. We do know hospitals are more heavily regulated than clinics of doctors. So this would clearly, if this goes forward, and they're regulated as a species of hospitals, would require additional requirements, more expensive requirements, and therefore would clearly be an undue burden on the women of Virginia if they're interested in a first trimester abortion, more expensive, less access, and Mr. President, I believe would also violate the Equal Protection Clause because you're treating this particular procedure, which is safe, differently than other procedures similar to it. Thank you, Mr. President.
Thanks, sir. The junior senator from Virginia Beach, Senator McWaters.
Thank you, Mr. President. I rise to speak for the amendment.
Senator has the floor.
Clearly, being a mere non-lawyer legislator, I have to believe that this is a patient safety issue, and being in the healthcare business most of my career, it really requires me to speak to this issue. I really have listened to the various debates on the Constitution, and I'm confused often between the Department of Health and the Department of Medicine. I think there are two different regulatory bodies. But in drilling down just on this bill, clearly just on this bill, There are currently today 5 different types of hospitals, including general, acute, rehab psychiatric, long-term acute care, and outpatient surgical. 5 different classifications in our code. This does not require these individuals to go to a med-surg hospital. This is simply suggesting perhaps even another classification of hospital, perhaps referred to as a outpatient hospital, and would simply require that the Board of Health promulgate new regulations for this type of organization and create standards of clinical practices for these abortion clinics that would be a new category. So again, it's not requiring someone to go into a med-surg facility. It's simply suggesting that these clinics currently providing these procedures do so in a clinically safe, responsible manner. Now, depending on, to me, no matter which side of the debate you're on, I think you have to agree that patient safety is our responsibility. And even under the Constitution of Virginia, I think we have decided that patient safety is of tremendous responsibility to us as legislators. Now, my problem is that we don't know today what's going on in these facilities. I had a good opportunity to discuss this with the junior senator from Norfolk, and he asked a question of me yesterday. I continue to point out that we have a facility in Virginia Beach that is advertising the fact that between 14 and 24 months, a person can come in, begin the abortion procedure, and then be sent out of state to a hospital in Maryland to complete the procedure. And I've continued to review this, and I've passed around to each of the legislators. It goes into very graphic, in-depth detail exactly what procedure would begin in Virginia and then would end in Maryland. And I'm just suggesting to you that the good lawmakers of Virginia decided that second trimester abortion should be done by a physician in a hospital. And this clearly is a case of a facility obfuscating Virginia law for profit on their part. So I just would suggest to you, we don't not know what's happening in these facilities. This legislation would give us an opportunity to promulgate regulations that would ensure patient safety. And I ask that we vote for this positively. Thank you, sir.
Thank you, sir. Senator from Fauquier, Senator Vogel.
Thank you, Mr. President. I would ask if the gentlelady from Arlington would resume the floor for purposes of a question.
Will the senator from Arlington yield for a question?
Mr. President.
Senator yields. Senator from Fauquier, Senator Vogel.
Thank you, Mr. President. I would just ask that the gentlelady, in addressing the issue of safety today for women who are having abortions in Virginia, is she aware of the physician in New Jersey who lost his license there because of issues related to his harm of women? Is she aware that he currently has 2 clinic locations in the Commonwealth of Virginia?
Senator from Arlington, Senator Whipple.
Mr. President, all the evidence that has been presented to the Education and Health Committee over the years has been that first trimester abortions in Virginia are very safe and have a very good record. I would say, however, if a physician is practicing illegally, then the Board of Medicine ought to get busy.
Senator from Fauquier, Senator Vogel.
And Mr. President, that goes to my second question, if the gentlelady would yield for a second question.
Senator yield for an additional question. Senator yields. Senator from Fauquier, Senator Vogel.
And is she also aware that in the clinics where he currently practices, he practices as a physician currently not licensed to practice in the Commonwealth of Virginia?
Senator from Arlington, Senator Whipple.
Mr. President, I have absolutely no personal knowledge. I have the pieces of paper that have been passed out on the floor of the Senate. But again, I would say, we have provisions for making sure that the practice of medicine is legal and done safely and carefully and according to medical ethics. And that could happen in any situation, but this is a responsibility of the Board of Medicine to see that that does not occur.
Thank you, sir.
Mr. President,
Senator from Fauquier, Senator Vogel.
I thank the gentlelady for Arlington, and just speaking one last time to this amendment, I would just like to further point out that this is truly an issue of safety, and I understand that there is a lot of background noise that takes away from the underlying issue, but I stand here before this body asking you that when you take this vote, when you vote for this amendment, please do consider the current environment in which women have the option to have this procedure done, and that there is no guarantee for women that it is safe, and that, in fact, these clinics have not been examined or have had any opportunity for evaluation since 1983. We don't know what is happening. And finally, I think it's very relevant for those who have spoken about the safety, that, well, if there were safety issues, we would know about them. Those clinics currently do not report issues the same way physicians do, the same way hospitals do, the same way clinics do, and ambulatory surgical centers do. And we had testimony when this bill came up before committee that really stunned me, truly, from OBGYNs who were the subsequent physicians treating women who had these procedures done in clinics, and of the terrible consequences of those botched abortions. And I will just tell you that I do find it remarkable that in 2011, with the current technology that we have applied to healthcare and the huge emphasis placed on quality of care, that we would find ourselves in an environment where we carve out for just a procedure available to women, a scenario where there is a lesser standard of care and a lesser degree of regulation than for virtually any other procedure. And I would also venture to say that were my male colleagues to find themselves in a scenario where they were going to seek a similar procedure of a reproductive nature, that they were only given the option to go to clinics where they are carved out as not regulated, not operating with the same standard of care, that they would have grave concerns. And so I would encourage all the members of this body to please be mindful that this is truly a serious women's health issue, and it's a serious issue of access to quality care. Thank you, Mr. President.
Thanks, sir.
I wonder if the senator from
Senator Whipple.
Fauquier would yield for a question.
Will the senator from Fauquier yield for a question?
Yes, I'm happy to yield.
The senator yields. Senator from
Mr.
Arlington.
President, I
Senator
would
Whipple.
ask the senator whether she realizes that, in fact, doctors' offices can be inspected and generally are upon complaint.
Senator from Fauquier, Senator Vogel.
Yes, Mr. President, I am aware of that case.
Senator from Arlington, Senator Whipple.
Mr. President, I would inquire whether she is aware of whether someone has complained about the clinic of which she speaks.
Senator from Fauquier, Senator Vogel.
Yes, Mr. President, I am aware that there have been reports of issues associated with that clinic. And then just speaking to that for one moment, I believe that when you are in a situation where you have a clinic that is required to self-report, and there is an opportunity for an evaluation from an outside regulator, that it is far, far more likely that in that scenario you will have accurate reports of issues that occur. In this situation, you are asking women who already are very sensitive about this matter, who are coming to a clinic already concerned about protecting their privacy, the fact that they have to go through the extra step to actually report such a physical issue that might result from a botched abortion is an extraordinary burden on these women that would not ordinarily be placed upon them were they in a ordinary surgical setting.
Mr. President, final question, if I may.
Senator has the floor.
I would, if the senator would yield.
She yields.
Thank you.
I yield.
And I would inquire whether the doctor's apparently illegal practice has been referred to the Board of Medicine.
Senator from Fauquier, Senator Vogel.
Mr. President, I would tell the gentlelady that I am actually unaware of the details of those issues and those complaints and what the current status of that is with the Board of Medicine.
Thank you, Mr. President.
Thanks, Senator. Senior Senator from Fairfax, Senator Saslaw.
Unlike quite a few people in here, having listened to 2 days' worth of debates, I didn't just arrive here from Mars. If anybody in this room thinks that this debate has been about women's health, get a life. I've been here 35 years. I've heard everything that you can possibly imagine on either side of this debate. Does anyone honestly believe in this chamber that there's 20 people who care about women's health and 20 people who don't give a darn? I ask you. Because that's approximately what the split is. This is absurd. And look at the amendment if you think I'm kidding. You're telling me it's safe to do this up to 4, but the 5th one makes it highly unsafe. Like I said, get a life. The only person that we have, the only physician we have in here got up and explained what nonsense this bill is or has become. You know it and I know it. There isn't but one issue involved on this piece of paper, and it's called abortion. I have not seen a single person in here who I know supports this bill come in and offer to put the same requirements on colonoscopy, cosmetic surgery, LASIK surgery, craniofacial surgery, which are every bit as invasive, okay? I had LASIK surgery done. You go blind for about 20 or 30 seconds when they open up whatever they open up in your eye. And you're telling me that that's okay? But somehow or other abortions are not? Like I said, then this thing isn't about but one issue, and one issue only, and it isn't women's health. Let me tell you, I don't have the word stupid written on my forehead, and I've heard this stuff for 35 years, okay? If I thought for 1 minute that this was about women's health, I'd throw a green light up there, but it's not. Thank you, Mr. President.
Thanks, sir. Senator from James City County, Senator Norman.
Mr. President, ladies and gentlemen of the Senate, for over 20 years, many of us have not been in the vortex of this very passionate issue that is before us today, that has come about as a result of a bill that lent itself to an amendment being placed on it. But the reality of it, it is what it is, and it is before us. It's interesting. I think many of us that in this body over the years have cast 10,000s of votes. And as we reflect on those 10,000 of votes, I can only speak for myself that I have never tried to legislate by the most egregious factual circumstance that any legislator would choose to lay out in supporting their arguments. I've tried to never legislate by historical transgressions which I may have inherited as the result of having no complicity but neither the opportunity to condemn. And I will tell you that I have reflected on this issue at great length, and I say to my dear friend, and I mean that sincerely, I have thought about it a great deal, and I have a life. And I am not unmindful as I look around and see my friends over to my right and my friends over to my left looking at me, and they are those who are supporters and they are those who are detractors, that they are looking at me in a number of different perspectives. I have been called many things as a Republican, ranging from a moderate to a rhino. I am not unmindful of the fact that I am a lawyer. I am not unmindful of the fact that I teach in a law school and have a modest understanding of constitutional law, and that, in fact, I try to impart that knowledge to those young aspiring lawyers who are eager to learn. And I'm not unmindful, Mr. President, that many are wondering how in the world, some of us could embrace this issue with the background of a lawyer, an educator, and a moderate, and I have reflected on it very seriously. And I say to my good friend, the majority leader, that I've been in a lot of law cases over the years, and I've seen a lot of spin on cases. And when I say spin, I am talking about how two reasonable, intelligent lawyers can listen to the same factual circumstances and come to diametrically different conclusions, and that those conclusions are not postured, but are based upon their individual analysis and how they come to the conclusion on what the facts are and what the law should be as applied to those facts. And I will say to you, Mr. President, that in spite of the passionate rhetoric, in spite of some of the egregious factual circumstances that have been laid out in the very spirited dialogue, that I go back and read what the amendment says, I distill it down to what its bare facts are, and I individually say that it has come down to be a health issue for me. And it is for that reason that I have comfort in voting to adopt this amendment. And I would hope that in spite of the passion that has taken place, that when all of this is concluded, that we each will be very respectful of the vote that each of us has taken and how heart-wrenching it has been to many of us on both sides of this issue. And I don't think that there's one member in this body that is taking this lightly and has not reflected on it and come to their own individual conclusions. So, Mr. President, I intend to concur with the House amendment.
Thanks, Senator. The question is, shall the Senate concur with the House amendment? All in favor of the motion will record the votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their votes? The clerk will close the roll.
Ayes 20, noes 20.
The ayes are 20, the noes are 20. The chair votes aye. The Senate concurs with the House amendments. On page 13,